Okay, going live. This is Senate Judiciary. This is April 7th, 2022. We are taking up H505, which has to do with drugs.
Shall I start?
Yep.
Okay, so good morning, committee. Michelle Childs, Office of Legislative Counsel. And as Senator Sears said, we're taking up H505 as passed by the House. And it's a pretty long bill and we have a lot of witnesses. So I'm gonna just do a very broad overview and then we can go back and detail when we pick it up and go through specific language. But I'm gonna start out just talking to you about the concepts in this. The main one being that it places the drug crimes into a classification system. There isn't the underlying statute for the classification system in H505, it's in H87 as passed by the House, which is in your committee. So if you decide to move forward with this proposal, creating a classification system for the regulated drug crimes, I could take the kind of legend for the classifications from 87 and import that into 505 because you would need that in order for it to make sense. And so basically what this does is it sets it into different categories. And I think the witnesses will talk to you about the work that went on and the different groups and the stakeholders that were involved in making these recommendations for the classifications and where these crimes should fit. So I'm not going to go through each drug and talk about each penalty. It'll get a little boring and take too long for this morning. So I'm going to just highlight what's there and then I'm going to show you the few other little things, policy changes that are in this draft. So I'm going to share my screen. First, I'm just going to show you what we have here for that's in H87. And so this is part of section 1 in H87. And we'll see what it does is it puts all felonies and then all misdemeanors into class A through class E. And then in section 52 there, it identifies what the term of imprisonment is for each class. And then in section, everybody have a copy?
I have to.
Oh, okay. And then in section 53, it does the same thing with regard to fines. So the idea being that there's consistency and within different, and there's amongst the various statutes and the penalties. So that if you have a certain, like a class A penalty, it's always going to be the same term of imprisonment, same fine across the board when things are done.
And this was developed by the Senate.
You know, I don't, Eric's been the one that's been, you know, really deep into working on the classifications, and this just kind of got pulled off as, I think, part of, in response to the work of the Justice Reinvestment folks on the drug crimes. And so I actually am not familiar with the whole backstory of how this classification.
I thought I remember that from the 87.
Yeah, I didn't do 87. I should probably know that, but I don't. But I'm sure the witnesses can speak to that.
Okay.
So I just wanted to show you that, so because that's going to be important as we're taking a look at H505. So now moving on to H505. So like I said, I'm not going to go through each individual drug in the penalty section, but I'll show you as an example for section 1. So this is amending one of the drug crimes, and you'll see what it does is that what you have there is you'll see normally the way that we do it, which you're very familiar with. It'll say person may be in prison for a certain amount of time, fine not more than X number of dollars, or both, and that's the general structure that we have throughout all of the crimes. And so this would be changing that and changing it and saying, you know, it'd be commits a Class C misdemeanor. And so you would look at essentially the legend and see what the penalty is for that. There's something that's a little different in this one and a few of the statutes, which is that you'll see this language that says notwithstanding 13 BSA section 53. And that is because there are a few crimes for which the existing financial penalty, the fine, is lower in current law than the classification thing. And so what the House decided to do with this was they didn't want to raise fines that to fit that classification. It was only, they only wanted to be able to either keep it the same or deviate down. So there is this language, it's notwithstanding language on some of the crimes, but not for others.
Just as regards to fines.
Oh, sorry.
Yes.
So, yeah, I wondered about that because I looked here and it says 1,000 on this sheet, Class C.
Right, but you'll see there under existing law, it's 500, and they
Yeah.
didn't want to be raising the fine in that particular instance,
So that's to keep it the same.
just to keep it the same.
Okay, can I ask a question?
Sure.
I hate to do it right away. So does this mean that the judge is bound by this and they don't have discretion of their own?
It would be the same as now, which you're providing what the penalties are, so they can sentence according to the way that they sentence now. So if this is, what is a Class C? What's the term of imprisonment for C?
10 years.
10 years.
For misdemeanor,
Well,
it's 6
in
months.
6 months.
See, so it's
Oh, that's a felony one.
C,
Okay,
Class C misdemeanor, so under here, it's 6 months. And the, and the
You don't want to
fine
get
is
bogged
that-
down in the classification system.
I'm just wondering, does it take?
I don't think, it's either not do this bill, because I don't see how, as we have time to create a whole classification system in this committee in the next week and a half. So the issue here is what penalties for what drugs. That's what Justice Reinvestment 2 is about, not about classification. We get bogged down in classification, we might as well throw up our hands and not do the bill.
I'm not saying anything about that. I'm just wondering, does a judge have leeway?
They do, just the way that they do now. It doesn't
They do.
change that in any way.
The
It's just the
maximum.
maximum, just the way that they can. They can do anywhere up to the
Up to
maximum.
the maximum?
So that doesn't change that in any way. Okay?
Yeah.
So I'm gonna skip over most of the classification stuff. I'm gonna move down to page 7, which is the next policy change. And this is, at top of page 7, this is an amendment to the existing cannabis law. And I don't know how this escaped us for so many years, but cannabis is spelled wrong in subsection D there. Somehow escaped me and the editors for several years while we were doing our reviews during the summer. So that's just fixing a typo. And then striking a language around the weight of the cannabis that's attributable to cannabis infused products shall be determined for methods set forth by DPS. And so first of all, that's just kind of like a dead preference because DPS is no longer administering the medical cannabis program. Also, it's unnecessary. So that you have to say how they formulate the one, what the ratio is. And so they, it could be that law enforcement might look to what the CCB uses or what the state forensic lab uses. My guess is that it's all going to be the same. And so, but the reasoning behind why you have this section is just because, let's say if, with an infused product, if you have a big cookie, right? It's not the whole weight of the cookie that counts as cannabis.
Right.
It's just going to be
The amount of
of cannabis that on the ratio. So that's that. But this is really just a technical. The next is I'm going to move to page 9. And so this is also having to do with cannabis, and this is section 6 of the bill for chemical extraction. You may recall that when you did cannabis decriminalization back in 2013, 2014, you created this statute so that people were not kind of using certain chemicals to be creating concentrates at home that might be dangerous. And so this is striking the allowance right in there in subsection A, which is, it says that currently, you know, dispensaries can do that, but this was a request, I think, from the Cannabis Control Board that be taken out. My understanding is they don't use those types of things, and so you don't need this exemption. Next policy change is on page 12, and this is in the crack statute. I'm sorry, the cocaine statute. It does have to do with crack, which is that.
But before you go there,
Let's take page 11.
could we take the technical amendments to cannabis law and put them in the miscellaneous cannabis?
I'm sorry, which amendments?
The two that we just went over, the one on page.
Oh, can you put them in there? Sure,
They look like miscellaneous cannabis issues.
sure.
On page 11, Michelle,
Mhm.
there's section 2 is struck.
Yes, I think that, again, that's part of the penalty policy stuff and the classification and all those things. Those are things that I think that the witnesses are going to speak to in their recommendations. So as part of just changing the penalties, they eliminated some offenses.
Right. Because that seems like a policy decision rather than a penalty decision. But anyway, let's keep it.
Is there any objection to moving those two technical amendments? One on page 7 and one on page 9 to the miscellaneous cannabis bill. I think they belong there, really.
Will do. So back to page 12, on trafficking for cocaine and the penalties is, a number of years ago, not too long ago, because I'm pretty sure I was the one that wrote this, the legislature created a different penalty for trafficking crack than for trafficking powder cocaine. And I think probably everybody is aware that people's views and policies have changed around that issue, and the racial implications of that. And so this is eliminating a separate crack statute.
Can I just ask, I've never seen permissive inference before.
Mm-hmm.
How does that differ from rebuttable presumption?
Oh, gosh. I don't know.
I mean, can you still rebut the permissive inference?
Yes, and I'd have to go back and look. It's been
Okay.
it's not something I was thinking about.
That's just for my own curiosity.
Okay. So next changes are starting on page 19. So this is just a change to section 11. This is doing the penalty change for depressant, stimulant, and narcotic drugs. But I just wanted to mention here is the language does in this section look a little funky. And the reason why is because last year the legislature passed a law decriminalizing personal possession amounts of buprenorphine. And but that is due to sunset next year, next July 1st. And so I needed to reflect that sunset in this language. And so that's why you will see language like that's in subdivision A1B that struck talking about possessing 224 milligrams or less of bupe. So that is not a new policy decision that's being made in this bill. It's just reflecting a prior policy decision of the General Assembly. And then we're going to go all the way down to page 33. And so we're going to take a look at section 21. And so it's good that.
Page 32, I have section 19.
33.
I'm sorry. All right.
Section 21 on page 33 at the bottom. And so it's good that we just raised the issue of bupe. So that statute is our catch-all statute for depressants, stimulants, narcotics, all the things that aren't otherwise specified in the law, like heroin, like cocaine, things like that. It's like a catch-all. And if you recall, is the standard of measure that's used there is benchmark. So there's like a certain dosage, and that's essentially something that's created. The benchmarks are created by the Department of Health by rule, and you can look up and see what the benchmarks are for that. And so the way that statute works is it's 100 times the benchmark or 500 times the benchmark. So this is kind of building on that concept. And I know that for those of you who have been on this committee for a while, I'm sure you recall, we have over the years looked at the issue of how do you determine what is a kind of a personal use supply. So in terms of trying to target the criminal statutes in a way that this committee has often talked about, you're not necessarily going after people who are struggling with a substance use disorder or something like that, and wanting, but looking at people who are selling or who are trafficking and wanting the penalties to reflect that policy. But it's always been really difficult to determine, well, what is a personal use supply? And I can think of probably Senator Sears, probably 15 years ago, sitting in here with Bob Bick. I don't know if he's still around doing this sort of stuff anymore, but kind of working with folks in the community trying to figure out those amounts, and it's always been very difficult. And so this is picking up on that concept, and it's creating the Drug Use Standards Advisory Board within the Sentencing Commission. And it's going to be composed of experts in the fields of general and mental health care, substance use disorder treatment, and drug user communities. And so
Nobody from law enforcement.
And what is the University of Vermont Law School Center for
Restorative Justice
Reform?
Bobby Sands.
That's Bobby Sands program.
That's not the University of Vermont, though. That's Vermont Law School.
Well, they have an arrangement with the UVM and DLS.
It could be.
Yeah, I can check to make sure it's the
Is he
right
going to be a
name.
witness, or are you going to ask him?
Pardon?
Is he going to be a witness that you know?
I don't know
I'm
if
sure
you know.
somebody up
Yeah, I can always Google it to see if it's the right name.
make sure.
So,
Again, my question, nobody from law enforcement.
no, I think that the purpose of the committee is to determine what is and that's in subsection B, you'll see, is to determine a benchmark personal use dosage and benchmark personal use supply. It's not about creating penalties or anything. It's about trying to focus on what is a personal supply of drugs. So it's focused more on the kind of health aspect of that.
But I'm not arguing with you. I'm arguing with the policy of having a board on personal use without any representatives from law enforcement who deal with many of these issues on a daily basis, particularly members of the drug task force. I think it's Lieutenant, I can't think of his last name, we had him in last week. It seems to me that there should be some representative of persons who are enforcing current laws and know, state's attorneys make decisions about, is this a personal use issue or not? Frequently, when they're developing their charging and their treatment and all that, it just seems to me that this is gonna fail in the public size, if you don't have representatives from those communities. I'm not saying they would dominate or anything like that, but those folks deal with this stuff on a daily basis.
And better to have them represented on the board so that when their recommendations come forward, they're not immediately opposed by law enforcement necessarily.
So I'm not arguing with you. You didn't write you wrote it, but you're not the manufacturer.
Oh.
Just the user.
I'm just the instrument.
That's right.
Anyway, I thought from my perspective, it's better to have them included, as Senator Ruth just said, than to have them excluded. And then, because I believe that the Department of Public Safety is on the Sentencing Commission.
I believe so. I don't know. I know there's a lot of people.
I think, as I recall, they
Right.
are.
And this is within the sentencing commission, and they
Understood.
give their recommendations to the sentencing commission.
I understand, but anyway, thought.
Sure. So you see there in subsection B is the goal of creating the benchmarks is to be preventing and reducing the criminalization of personal drug use. And the board can provide additional recommendations to both the Sentencing Commission and the General Assembly regarding how to transition from a criminal justice approach to a public health approach to addressing drug possession. So subsection C, the board's going to be convened and chaired by the Deputy Commissioner of Health for Alcohol and Drug Abuse Programs. And then after receiving nominations from harm reduction service providers, the Deputy Commissioner appoints 3 consumer representatives to the board who have lived experience in drug use and consumption practices. And then those 4 people.
So, I'm sorry, consumer representatives, or by consumers, we mean
Drug users.
drug users. And then how do we select their representatives?
So there's you see there's going to be nominations from harm reduction service providers. So people will put forth, so people who are working in that field would put forth names to the deputy commissioner, and the deputy commissioner would select 3 people.
So I just think it's a little odd. I understand the lived experience concept, but are we saying basically these people would be on the board because they are current drug users?
I think that it's not super specific with regard to what their lived experience is, but it would be up to the harm reduction service providers to be providing names and backgrounds on these nominees to the deputy commissioner.
Yeah.
For the deputy commissioner to make
I mean,
their
who
selection.
have lived experiences is a little vague. It could be in the past or it could be.
Yep, and then there's a lot of people who have past
Yeah.
issues who are now working in the recovery.
I was gonna say,
community.
I know that's a common path, but I wasn't sure what the intent here was, whether it was to be representing current consumers. Consumer just strikes me as an odd word to use there, but anyway.
They're going to appoint the remaining board members.
I know some might.
You know, they're appointing the remaining board members.
Yeah,
I think they'll show up.
Yeah, I mean, there are people who are working in the peer recovery centers and who are very capable.
And there are,
But it doesn't say that.
Just says with lived experience.
So they may still all be serious drug users. Which, one,
Right, well,
they're not.
that's what the House did.
1, 2, 3. There are 25 people. 6.
Well, Michelle now, she's gonna open that, right?
6 people.
Sorry.
We're not great with Michelle. leaves during the break, call David Schultz.
Don't tell them
No,
to
no,
touch the
no.
curtains. I'm gonna make them all nice after I finish.
Hold on, school.
You have to measure from the floor to see where the sash goes.
Side goes.
So
Um,
anyhow,
Okay, so then you'll see, in subsection C, who else is on the board? So 2 representatives from harm reduction service providers, an expert on medicated assisted treatment, an expert on human behavior and addiction, expert on substance use disorder treatment. Then someone from the restorative justice program, an academic researcher specializing in drug use or drug policy. So they're going to have the assistance of the Division of Alcohol and Drug Abuse Programs. They're permitted to have a per diem for not more than 3 meetings to develop the initial recommendations and once annually thereafter. And then on or before September 1st of this year, the board is to provide to the Sentencing Commission and to the General Assembly the recommended quantities for both the benchmark personal use dosage and benchmark personal use supply for each category of regulated drug, and a recommendation as to whether heroin and fentanyl should be combined into one statute. That's something that the state's attorneys have been looking at, they've proposed doing, and the House, there was not unanimity in there about how to move forward on that, and so they wanted a recommendation on that from the board. Then on or before December 1st of this year, based on the benchmark personal use and benchmark personal use supply recommendations, the Sentencing Commission is to make recommendations to you regarding adjustments in the amounts for possession, dispensing, and sale of regulated drugs, and a proposal for combining heroin and fentanyl statutes if recommended by the board. And so this is where the thing about, like, you know, should you tweak the amounts of like how the tiers work within each regulated drug, and that would, so those policy recommendations, so it would be the board coming up with, this is what we think, you know, a personal use supply is. They would recommend that to the commission. The commission then would be making recommendations to you on how to tier the amounts for the penalties and any recommendations on those, as well as how you should do a combination fentanyl and heroin statute if that's what's recommended.
There's not much time for them to do all of this, to get to even find these people and appoint them. And then start, recommend passes July 1, and then by September 1st, they have to provide it. Is that right? I mean, that's what it looks like.
Yep.
So,
You'll see on section 22, the board sunsets in 5 years. That's just like something that's standard that the House Government Operations is, maybe Senator White, you're doing it as well over here, which is just like an automatic sunset.
But-
of these types
but-
of things
but-
in 5 years.
but the board sunsets in 5 years, but the Sentencing Commission sunsets this year.
Correct, I know that.
Is somewhere else, because they can't report to a commission that no longer exists.
Correct, and I heard different things about whether or not that was gonna be extended or not.
Well, it might be in the miscellaneous procedures bill, but
Maybe we should duplicate it in miscellaneous judiciary.
yeah, I just don't understand. We need to coordinate those 2 things, because Sentencing Commission is due to sunset this July. So it needs to at least be extended another year, but if they're gonna be sunsetting in what, July of
5 years.
5 years, does that mean we keep the Sentencing Commission another 5 years?
You could do it.
Logic would suggest.
It would.
Unless we
Well, this
change-
wouldn't create that, this obviously doesn't extend the sentencing commission, so if there was no sentencing commission. I mean,
Who are they reporting to?
well, you would have to decide whether or not you want them to be housed somewhere else, or whether maybe you just want their initial recommendations. What this sets up is you want their initial recommendations, and then after that, they would just meet once a year to do that. Maybe you would want them to continue, but put them in a different agency, or figure out some
Well,
other.
it's something that we have to work out and decide policy-wise what we want to do. Because I think you have, board is the subcommittee that basically of the sentencing commission. So if there's no sentencing commission, you're no longer a subcommittee of the sentencing commission. Little technical detail that we need to work on.
And something that I will mention is that this proposal here is based on a law that passed in Oregon a couple of years ago.
Yeah, I actually don't have a problem, some issues with the makeup. I don't have a problem with having this group. I think it's a great idea to better understand what those amounts of personal possession and other issues should be. It's the question of how long, and I know appropriations is certainly going to ask that question. We have a certain senator who serves on appropriation, who always questions the number of meetings and the boards and commissions and so forth. It's very adept at luring them from the policy committee's position.
Who's that?
I'm not naming any names, Senator Nedgood.
I'm sure not.
Okay, I'm gonna vacate the witness chair, and we've got a lot of witnesses this morning.
Yeah, and by the way, and I don't know that we'll get to everybody today, but we definitely will in the coming week and a half.
Is next week or last week?
I hope it's the week after, but there's no guarantees in this building.
I only slept about 2 hours last night, so it just rolled me over, so I
The
don't.
directive I got from leadership was decide which bills are gonna die
I know.
and which you can advance in an appropriate amount of time,
My grandmother's voice.
in order to have confidence.
And I just don't play there, we have to do something, so I got up.
This one will require a conference committee, as will the ceiling bill. So the quicker we get these two done, the better. All right, so our first witness is the Honorable Judge Thomas Zone.
Good morning, Tom Zone, Chief Superior Judge. And also, for purposes of, I wanted to make sure Senator Sears could see we are open today.
We are, okay.
Are open, ready to go. I'm also the chair of the Sentencing Commission, so if it's okay with the committee, I'm going to go a little bit in reverse order and address some of the questions that I've heard.
Yep.
Number one, yes, Commissioner Sherling from the Department of Public Safety does have a seat on the Sentencing Commission. H 729, which is the miscellaneous judiciary bill, which came over, Section 5 seeks to repeal the sunset of the Sentencing Commission from this coming July of 22 for another year, July of 23. And so it would extend essentially the Sentencing Commission for a year. When we look at the drug advisory panel that the committee was just discussing, I agree with Senator Sears and the committee members, and that is, it is difficult to have, I would suggest, a group who is operating under a group that's going to go away. And so one, I would suggest, easy fix for that is you take Section 5 of the miscellaneous judiciary bill and extend the Sentencing Commission until July 1st of 2027. And that would have the two dates coincide. And you would not have the risk of having, if you decide to go in the direction of the drug advisory panel, you wouldn't have the risk of having that outlast the group that oversees it. As far as the bill itself, H505, I did want to touch on the drug advisory panel first. We've tried to address the issue of amounts and substance of the personal use statutes in the commission. Frankly, there seems to be an agreement that yes, the amounts are low and need to be adjusted, and that's where things get bogged down. There doesn't seem to be the ability to get a uniform agreement from the stakeholders on the commission to decide where we should go there with the numbers. And so that leaves us with, yes, we can vote something out, bring it to the legislature and say, here's what we think. And there will be differing views and it'll play out in the various committees, or maybe there's an alternative. And I think that what we see here that the House has sent over is a suggestion of an alternative to try to get something as far as additional information that we can utilize in making those determinations. And so as a policy to have another group, we would support that. The Judiciary and I think the Sentencing Commission, I would support it. I can't speak for the entire commission. I haven't floated this with the commission, but I think it would be a positive step. That being said, having listened to the walkthrough, there are a number of identified, I would say, issues, if you will, with the way that bill comes out. I would first agree that one of the things we would want is credibility with any type of board. And I think that where Senator Sears, you mentioned law enforcement, I don't see any reason why there shouldn't be a law enforcement officer on that board. I also do think that when you look at the structure, as I understand it from reading the bill, it takes the deputy director, who then has 3 term consumers, which I believe are active drug users, who are nominated by harm reduction programs. And then they, as a group of 4, it looks like, decide who is going to be the members from the other constituent groups. And so you certainly may wish to remove that type of questioning, because I think, as Senator Nitka pointed out, if you wanted to put September 1st in as a date, it would certainly seem quite ambitious to try to get there by then. And if you're going to have to go through an appointment process of basically a double appointment with a nomination, appointment, and then new appointments, it would seem as though you're bogging down the process in trying to get the nominations, and maybe there's a better way to do it. And I would leave that up to the committee as to the policy of how it wants to go forward there.
Jody?
Yes.
Sorry to interrupt. Before we move on from that, it strikes me as a novel idea to have active drug users appointed under the theory that the fact that they are drug users is their qualification, and then to have those people select the other members of the board. Do you want to speak to that?
I would say that would be a policy determination, but I would agree with you when you use the phrase novel. I am unaware of that procedure being used in other areas. It's certainly one way that, first of all, the reality is that the input of someone who is currently who's suffering from a substance abuse disorder is important in determining the issues that the board would have to determine. Whether that means that they have to be someone who is doing the selection of the other board members and serve on the board, that's a policy decision. Certainly they can, even if they're not included in the selection process, they would certainly be able to appear, provide valuable information to be considered by the board. And so I'm unaware of other boards where it has that structure. Again, that would be a policy decision. Excuse me. So basically, as far as the board's concerned, it makes sense to try to structure a board that's going to kind of get us through that hump and over that hurdle of, okay, what is the real numbers right now? Because again, there is a recognition that this is something that needs to be addressed. The weights that we're using and the amounts we're using are outdated, quite frankly. And so that's something that needs to be addressed. And this is one way that it could possibly be addressed. At the outset, Senator Sears, you mentioned about a week and a half and an entire classification scheme. Having heard that, I would simply offer that we do support the classification scheme, and going forward, as far as the amounts and whether it's a class A, B, C, D, and what it looks like, those are policy decisions. But having a classification scheme brings a consistency, a transparency, and a predictability to our statutes on criminal justice matters that we don't have now. We have things all over the board. There's no consistency. And so we do think going in that direction is important to get that consistency, and that's going to take time. And Ms. Childs pointed out that even if this committee said right now, well, yep, absolutely, H505, best bill ever written, we want it as written, you still have to bring in H87, because this can't stand alone, because H87 was what has the classifications in it. And so if there's any questions, I'd certainly be happy to answer them.
No, I don't think so. Thank you.
And I would note that I historically will try to stay on when the committee is meeting, but I do have testimony to give in another committee, so I will be signing off if that's okay.
Okay, thank you.
Thank you.
Thank you for being here.
Have a good
I'm
day.
gonna jump ahead in the agenda because Dr. Seaman has other things going on, and I hope nobody objects. Doctor?
Yes, thank you so much to the members of the committee and chair. My name is Andrew Seaman. I am a medical provider, an addiction specialist, an internist, and an associate professor of medicine at Oregon Health and Sciences University. But I do, and also that why I'm here is I'm the medical director for Vermont of Better Life Partners, which is a harm reduction oriented treatment organization here in Vermont. And I'm just right down the street from you at 100 East State Street. And I'm grateful to have another opportunity to talk about this. I think that at its nature, this is a harm reduction bill. It does move some things forward. I think I agree with many of the things said that a lot of the ways that the current statute reads around quantity limits and so on are just really based on nothing. Or some historical remnant, and it's hard for me to determine what that is at this point. But there are these, I think, a couple things I wanted to make some general comments about how you might think about quantity limits and some additional considerations from a medical perspective and a harm reduction perspective. So one, that, I think some of these changes are really pretty small changes, and I do. I think that it is a very smart approach to get a body of folks who understand what actual use is. So these are people who use drugs, people who care for those who use drugs and help advocate for them. I think that is a very smart approach. I do think some of these are so egregious, and I'll talk a little bit more about the heroin quantity limits, that it would sure be nice to fix those a little bit right now, as I think they made an attempt to do in the House committee, and I can talk more about that. But I think the overall structure of the bill does make a lot of sense to me from a medical perspective. A couple of things I just want everyone to be aware of here. One, a lot of these, when we're looking at the quantity limits, they're talking about weighed amounts of a substance that is mixed with all kinds of other stuff. And so one of the things you have to think about is that if you're buying a gram of heroin, for instance, that gram of heroin may actually contain 0.3 grams of heroin. And it may be 0.3 grams of heroin from this supplier, 0.7 grams of heroin from this supplier, whereas people who use drugs will go into withdrawal if they go from 0.7 to 0.3 milligrams and so on. So I think this is one of the reasons why it's so important that we're not so incredibly restrictive on what is defined as personal use, and why one of the reasons why these very arbitrary quantities are potentially very harmful for people who may or may not think about them when making decisions on how much they purchase at a time. So that's one thought. Happy to take questions on that. Another thing to think about is that there are a lot of reasons why defining personal use, even as what people use in a day, may actually cause a lot of harm. And one of those is that when people use drugs, they have a supplier. Sometimes they're a friend, sometimes they are, a small level dealer. And when they are forced to go out multiple times, potentially even in a day, to give you an example, so currently it is a class B, on heroin. It is a class C felony to use upwards of 2 grams of heroin a day, when a significant number of people who I care for use well more than that, 3.5 grams of heroin a day. So we're talking about a felony charge for someone who is using just enough to get them through part of one day. If we are saying that a standard should be set such that people would need to go out multiple times a day to purchase just enough to stay well for that day, we are putting them at harm's risk. One, what if they can't get a hold of their supplier again in the same day? They may have to go to a different supplier. And what happens there? Again, changes in purity. How much will this new drug be cut with fentanyl or some other fentanyl analog? So what they use the exact same amount in the morning might be a lethal dose in the evening. So that is one really significant thing. If what we're trying to do is keep people from dying, so they can rejoin, do what they need to do to be well and be integrated within society and our communities, we really need to think hard about what we're doing by having these really restrictive quantity limits. Also, when people have to go out and are being put at risk of potentially going through withdrawal, especially from an opioid, because they have these very small quantities on hand, that it puts them at risk for hepatitis C infection because people are more likely to share someone's rinse or cotton. These are things that people can do sometimes to not withdraw as hard when they run out of their supply. So they share someone else's rinse, that's the water that's mixed up when they cook it, or their cotton, that's the filter that they use. It puts them at risk for maybe using someone else's syringe. And not just from a health cost, but just from a personal wellness cost to people who may get HIV or hepatitis C, but just from a cost, societal cost as well. These treatments are extremely expensive. So there's so many reasons why we really should not be asking people to have these really tiny quantity limits that in no way put them anywhere near sort of distribution quantities. Another thing, I guess I just wanted to really briefly talk about the heroin quantity. So that the 2 gram limit is so far from making any sense. And I think in talking to the state's attorney in the House committee session, there were some comments around average use, and they're getting information around average use based on how much they're confiscating. I just want to say that I think this is not based in reality. What people have on hand on them, it does not reflect personal use quantities. The way we learn about personal use quantities is talking to people who use drugs, being trusted voices like a harm reductionist or maybe a more harm reduction oriented clinician, and talking most importantly to people who use drugs themselves. They are truly the experts on this. There is nobody who knows more about how much someone is actively using, not how much they should be using, not all of these other factors, but how much people actually use in the community than people who use drugs, which is why I'm actually a huge fan of how the language is written for the drug use advisory board. I think that if really, we're not asking about what we wish people used, we're not asking about what the law enforcement is confiscating when they pick people up. We're asking what people actually use. And then and if that's the case, the experts are people who use or who did use. So I don't think the language, with all respect, says that they have to be actively using. These are people who are engaged with harm reduction resources, who are thought to be who will be thought to be very reliable, someone who can show up, who can really provide meaningful input. And I really think those are the experts. I think that the harm reductionists, as being a first line nomination process to nominate these people, is exactly the right thing. Again, the harm reductionists are the most trusted voices to people who use drugs because they know they will not be judged by them. And so those are the folks who should be selecting this group. I do want to say I understand the senator's concern over law enforcement not having buy-in on these quantity limits. I completely understand that. I guess I would just say that, again, we're not trying to define what people wish these quantity limits are. We're trying to define what is the most accurate representation about what people are using. And I can't find any situation where I can imagine that going off of the data that a law enforcement person has based on confiscation quantities and so on will trump the information that comes from people who are actively using drugs and the people who are caring for them and are trusted by them. So I love this language. I think the timeline, I mean, obviously I will acknowledge that you all know much, much more about process than I do. And I know that this will mean a lot to people in the harm reduction community. And I think that we can find these people quickly. And I think we can get a board established. So I'm not terribly worried about the timeline, but I do respect the experience of everyone else in the committee. So I just want to say that in the big picture, I think this is it's a little bit of a baby step, but it is a movement in the right direction towards us redefining how we think about drug use and moving away from a punishment-oriented approach to an approach that is more population health-based, more evidence-based, and really putting these decisions back into the hands of people who really understand these problems on a really deep level. So with that, I'll happily stay on for a while, and I do appreciate you prioritizing this and taking
Senator
time.
White has a comment or question.
I just have a, kind of an observation about having a law enforcement person on the, I can't even remember what it's called now, but the drug advisory, whatever that was called. And not necessarily to help determine what a legal, I mean, a personal use amount might be, but oftentimes when somebody is on a panel like that and is listening to other people, they begin to understand the underlying issues and what is really going on. And it might be helpful to have someone there to participate in that discussion so that they can see, so that there isn't an immediate just negative response to whatever comes out of the advisory board. That's how I was thinking of the presence of a law enforcement officer there.
Absolutely. I think if I may respond to that, I think that makes a lot of sense. From my perspective, as a medical provider, as long as the people with the most valid information are making the determinations on the quantities, and that the structure of the board and the decision-making process of the board allows those individuals to really be determining the actual personal use quantities, I would have no problem with that. I just would, yes, period. I would have no problem with that. But I think that we need to stay true to the goals of the advisory board.
Senator Baruch.
Thank you, Dr. Seaman. I'm just going back to the process for appointing the board, the multi-tiered process. So when it says the deputy commissioner shall appoint 3 consumer representatives, how do you understand consumer representatives with lived experience in drug use and consumption?
So these were 3 consumer representatives nominated by harm reduction professionals. Is that right?
Yes. Yes.
I would say that it is not defined as active or former use, and that I would see benefit personally in having probably both people who have past drug use and active drug use on the board. I think that this is a very fast changing environment, and what was true even a couple of years ago is no longer true about drug use patterns with the change in the drug supply. So I don't know, I would define it as anyone with lived experience, and that I think it's good to leave it open for people in the harm reduction community to nominate individuals who can bring a diverse array of background experiences.
And I fully support that idea, but the way it works is the nominations from the harm reduction community, deputy commissioner appoints the 3 consumer representatives, the people with lived experience of consumption. Then the deputy commissioner and the 3 consumer representatives, in other words, the majority selecting the rest of the members would be the consumer representatives. And among those they are appointing are representatives from harm reduction service providers. So in effect, you have harm reduction specialists advising the deputy, who picks consumers, who then pick harm reduction specialists. And I'm wondering why we need the step where the consumer representatives, in addition to sitting on the board, providing their experience, which is very valuable, why they are in the driver's seat for selecting the rest members. And I'm wondering if you can speak to that.
Yeah, again, yes, I think that what I love about this is that this is trying to hold true to what we are doing as a community and moving towards as a community, in that we want no rules to be made about a population without that population really being in the driver's seat. And so I think I understand the discomfort with this and the feeling of this being novel. And this really pushes us and pushes our comfort zone a little bit into allowing the people who these laws will affect to make the most important decisions about these laws. And if I
Sorry.
may, forgive me.
Yeah, go ahead.
So I think that I understand how that creates a little bit more of a convoluted process, but in practice, what is almost certain to happen is you will have harm reductionists who will nominate these people. Those harm reductionists are the trusted voices. And when asked to determine who will be a fitting person for this committee, will be doing so in consultation with them and with their own personal experiences of navigating with providers and other folks in the community.
Understood. You've said several times that the harm reductionists are the trusted voices. I'm wondering why we're not letting the harm reductionists appoint the rest of the board. So in other words, we have 3 consumer representatives whose only qualification is that they have lived experience in drug use. But we're asking them to pick representatives and experts in treatment programs, human behavior, substance abuse, legal reform, things that they may have absolutely no knowledge of. And it seems to me that I understand the concept of nothing about us without us. So having those people on the board makes perfect sense, but asking them to select experts in field in which they are not themselves experts seems a little strange to me.
And I understand your point, and I think it might be asking a lot of people. And I think that if the committee feels like some language changes that would allow harm reductionists to make these decisions, at the about the broader board together, I would defer to the committee. I do think that if you were to ask a harm reductionist, they would likely say, we want these folks to make these decisions. But I consider myself a harm reductionist, but I can't speak for the organizations who will likely be represented on in this committee.
I do appreciate your comments, Doctor. I would just point out that they will be making recommendations to a sentencing commission that's made up of various players in the criminal justice system. And the sentencing commission will be making recommendations to the legislature. So at some point, you need the credibility, and I think that would come from my own personal experience is that those consumers have a great voice, but also people who work in the field have a great voice, like yourself, who should be heard on that board. It would give more credibility to both the sentencing commission and the legislature once the sentencing commission makes its recommendations. So it's a sticky wicket, as some people used to say, but I think we have to find our way to give credibility within the consumer, if that's what we're going to call it, community, but also credibility with those who are dealing with the criminal justice issues, from corrections commissioners to law enforcement, state's attorneys, defenders, etc.
Thank you, Senator. Yeah, I respect your experience in moving things through the system, and we clearly want this to have an impact, right? So we're on the same page about that. We want any advice that comes out of this committee to have an impact on statute. And I would again just say that as long as the individuals who have the most valid data on what is happening in the community, if we're talking about determining something that is what is happening in the community, those folks, I think, need to be able to have the say on what these personal use quantities are, not again what they should be. But I fully hear and understand the argument of having a committee that allows at least receptive, perspectives on all of this. One of the things I'll say from a medical perspective and a researcher is when we do things called meta-analyses, where we combine data together or study data together, that if you include high fidelity data and combine it with less high fidelity data, which I would say is what the data coming from law enforcement would be, just it is less representative, that it actually makes the overall study data for this study called the meta-analysis less valid. So that's the perspective I'm coming from as a researcher and a scientist.
I think we fully understand that. Just as law enforcement isn't the majority of the sentencing commission, there would be a majority of this commission. There would actually be a small minority within that system, but at least have a voice and understand some of what's happening. If you have time, my final question really has to do with determining the user amounts, particularly for drugs like heroin, which are so addictive. My background was I did work at a drug treatment facility, but that was over 40 years ago, and drug potency and et cetera have changed dramatically. But I remember talking to folks and talking about getting back to getting normal. It wasn't about getting high, it was about getting normal. And in today's, are there geographic differences in what gets you to normal in Vermont? Are there amounts that are different from one community to another?
Yeah, it's a great question. And I think it gets back to what I maybe attempted to say not very clearly earlier, is around even not just regionally, but just in any individual community there can be significant differences in the potency of a drug. And the bigger issue now, of course, is not the heroin, but it's the fentanyl and the fentanyl analogs. And so, yes, there are regional differences, but those regional differences can change if there's a change in supplier. And there are also, differences from time point to time point. And so I think, and this is the challenge with some of these discussions we've had with law enforcement that are based on sort of averages, is that we actually don't want averages. We want confidence intervals. We want the broad range of what's personal use. And that takes into account some of those differences in potency, and trying to figure out how do we come up with personal use quantities that balances the known harms of causing people to have to go out frequently to get more and more small quantities of drugs.
Thank you. Any other questions for Dr. Smith? Thank you so much for being with us this morning. I hope you'll be able to follow our deliberations on this bill. And if you have any thoughts, please send them to us.
Yeah, thank you all. I really appreciate your time.
Okay, I am going to take, I apologize to the other witnesses that we didn't get to you this morning. I hope you'll be available in the near future when we take this up next week.